Hi, all, and welcome to Lunchtime Topics. I'm Kate, the Director of Programming and Communications here at the Creative Coast in Savannah, Georgia. The Creative Coast is a 501c3 nonprofit, and we exist to catalyze the innovation economy here on the coast of Georgia. The Lunchtime Topics is a bi-monthly program of the Creative Coast that features an expert speaker who shares their wisdom with Savannah's community of startup founders and innovators. Today's guest is Jackie Hutter, who is the founder and principal of the Hutter Group, LLC. Ms. Hutter is Zooming with us from Decatur, Georgia today, and she is going to be talking about how startups can leverage patents and IP to help them achieve their business goals. So Ms. Hutter has represented companies of all sizes in her 25+ year career as an IP attorney, and today she exclusively works with startup and early stage business teams to assist them in designing and deploying and managing IP strategies directed towards maximizing their company's revenue and exit values. In her IP consultancy practice, the Hutter Group LLC, she serves as a strategic in-house IP counsel for several companies on a part-time basis to provide these smaller companies with basically in comparison, incomparable level of IP representation as that of more established companies that are seeking to partner with or exit into. So she also has experience as a startup founder herself. From 2011 to 2015, Ms. Hutter served as the CEO of a startup battery-related company. And basically this experience is kind of what led her here today to doing what we're going to talk about today with IP strategy. It's provided her with basically an insight and insider's knowledge to the lean startup method, which she uses in her business to provide clients with IP counseling focused on the unique business needs of startups and early stage companies. So lastly, Ms. Hutter's also been recognized for each of the last 13 years for her innovative insights into creating value from IP strategy with the peer-awarded Top Global IP Strategist by Intellectual Asset Magazine. So thank you for being here today, Jackie. We appreciate you coming on to chat with us about this topic.
Oh, thank you. Thank you for having me. I'm a big fan of Savannah, and I look forward to spending more time there in the not too distant future.
Awesome. Well, let's just go ahead and get into it. So first question I always ask is when we bring in experts, can you share a little bit more about your background and why you became passionate about this particular topic?
Sure. I'm a natural innovator who became a boring attorney by accident, I think. I started my career as working in innovation in a hair care company. I have a degree that allows me to be called a hair chemist because that was kind of the coolest chemistry I could find, the coolest thing I could find to do with my graduate degree. And I did that for a few years and realized that that was not really where the fun was. For some reason, I thought that being a patent attorney would be fun. Was totally wrong about that, but ended up with a very traditional career where I represented mostly large corporations that were doing interesting things, but patents and IP are not critical for large companies or even established companies, even a small company that has customers, because they're not going to probably go out of business if they mess up their IP strategy. But I did get closer to innovation and to the client, to the business, when I left the traditional practice of law and went in-house to Georgia Pacific and was put on an innovation team where I actually saw my products on the shelves in the grocery store. It was kind of cool. And I realized that patents and IP really only made a difference at all if they were helping my business, helping my clients make more money, which was a flip from where I was before, because everything I did about IP made money for me as an IP lawyer. Whereas in business, very little has to do with making money in IP. So I learned to align the business aspects that I was working in with my IP work, which is quite frankly an unusual way to look at it. Most IP makes zero value, and that was not a world I wanted to live in. And I also wanted to live with innovators. because innovators are solving the problems, right? They're doing cool stuff. They're identifying problems and they're bringing solutions to people who need those solutions. And importantly, if you have a solution that's important enough that people will pay for, intellectual property is how you get paid back for doing that work, because it's not stealing if it's not protected. And IP gives you the means to protect that great idea that people are paying for.
Great. Okay, so when we were talking, we talked a little bit about when patents matter and when it's important to think about patenting. And I know you talked about the word innovation, and I know that I've seen some of your other presentations where you differentiate between invention versus innovation. Can you touch on when patents matter and kind of elaborate on this idea of innovation and what that means in terms of patents?
So we tend to think of patents in what did you invent, right? What is this thing that is the outcome, the output of this hard work that you did? Okay, but an invention looks at the past. It is a way to capture and collect past activity in the form of protection that the United States and other countries recognize in the form of patents. Very expensive, but that's the way the world has evolved. But innovation is about the future. No person gets a patent to protect what they did in the past. They get a patent to protect their future revenue associated with that work. And so that causes me to distinguish inventions, that is what you did in the past, that output. If you've, to simplify it perhaps, if you're baking a cake, all those ingredients you put together and mix up, you put it in the oven, that outcome is the cake. That's an invention. Okay, the equivalent, metaphorically, that's an invention. But who might care about that cake, and who might pay you for that cake, and who might pay you enough money to make it worthwhile for you to make that cake, as well as to scale multiple cakes? That's what we're trying to protect. And that may have very little to do with that point when you took that cake out of the oven. It's what people will pay you for and what the outcomes associated with that cake are. I hope that makes sense. I tried to simplify it because patents and inventions are very complex topics, and quite frankly, patent attorneys like to make it complicated, and because it makes it hard for people to really understand what the real reasons they're doing things are.
Got it. So,
if I might, Kate, if I might, for 1 other second.
Yeah.
The other thing is, we anybody who's worked in the patent space before, been involved with that, the first question that we are trained as attorneys, as well as the general public, as folks are on this call are trained to ask, is this patentable? Is something patentable? Is it novel and obvious? And in the innovation space, that's not a relevant question, because if you're solving a problem that's never been solved before, and it's big enough that people care, it's by definition patentable because it's never existed before and it's meaningful. So the question then has to become not, is it patentable because it is patentable? It's, how do I protect it in a way to make sure that I get paid back for all the hard work of solving the problem?
Got it. Okay. So kind of related to that, there being a misconception on patents and when they're needed and what they're needed for. Can you talk about what some of the biggest misconceptions when it comes to acquiring patents, or maybe the better word is myths? Can you kind of talk more on that?
Well, first, that by getting a patent, you'll make money. Very, very few patents, vanishingly small number of patents are licensable. Okay, or buyable, notwithstanding all the commercials you see on late night TV. Okay, all the infomercials, just forget those, put those out of your head. People don't buy or license patents. They buy or license business models that they want access to. So any patent, people buy businesses without patents, but but businesses that are covered, that their value proposition, that their value is covered by a meaningful patent, helps that business be sustainable because it is protected. Nobody should be getting a patent unless they have a customer. Nobody should be getting a patent unless that customer is scalable. And just another myth is just because you don't get a patent today doesn't mean you can't get a patent in the future. If you're an innovator, you're going to continue to innovate. You're going to be continuing to talk to the customer, learn more, find out what they need. And quite frankly, from my view as as an IP strategist, not as a lawyer, not as an IP lawyer, but as an IP strategist, is that you better, you don't want to be spending, 5,000, 10,000, 20,000 or more dollars on a patent that's going to make the patent attorney money. If you don't have any customers, you should be spending that large number of money that would otherwise be associated with patents on developing your business and finding those customers. And only at that point where you have something, you say, hey, this is go time. Is it the right time to figure out whether or not a patent is what you need? Importantly, 100% of patents make money for 100% of patent attorneys. Very, very few patents make money for business.
Okay, great. So, okay, so you talked a little bit about when we chatted about individualized patent strategy, and you gave me some examples of what that means for a company that has gotten to the stage when patents matter. I think we were talking specifically about a company where they weren't quite ready for a patent and you sent them back to the drawing board to do a little bit of more product market fit. Can you talk a little bit about that in general terms, what an individual's patent strategy kind of is and how it applies to some of the businesses you've worked with?
Would this be a good time to go into the lean startup framework as it
Let's do that. Yes.
Okay. So one of the, I alluded to this before, but one of the things that's not well understood in the patent world, and certainly more so in the startup world, but not as much as I had hoped, is that every patent that we have today, we should say every patent attorney is trained to understand patents in a framework that is built upon existing companies, established companies. And those companies have customers. They know who their customers are. They may be delivering new products to those customers, but they have those customers and they know who they are. They better know who they are. They also have distribution channels. They also have suppliers and manufacturing plants, all the kind of stuff that makes them an established business. So the things that they do to deliver new products to customers are very different than startups who don't have customers until they do have customers. They don't have suppliers until they have a product that they need to supply. And so I said a few minutes ago that you shouldn't file a patent until you have a product, and that's where this product market fit analysis comes in. I had a client many years ago. I'm still working with them now, and they're doing very, very well. They started as two guys in a conference room at Georgia Tech, and now they've got dozens of employees, and we're still filing patent protection. But it was a technologist, a very smart PhD graduate, obviously PhD graduate from Georgia Tech, but a very innovative PhD graduate from Georgia Tech, and a serial CEO who was looking for an idea, technology to bring to market and validate. And we sat down once a month for about an hour a month, and they were telling me how their technology was evolving and what the customers were saying to them. They were doing customer discovery in real time to see not whether their technology was awesome, but whether the technology was deployable to solve a problem the customers had. And we could have filed a patent from day one because the technologists had some really cool technology, but the technology didn't have any value until there was some degree of validation that somebody was going to pay for it. And finally, after a few months, it felt right. And I can't even describe it as anything more than it felt right. We had the response from customers It was in a construction related space. We had response from customers who were like, yeah, we think this might be something. And we filed a patent application, provisional patent application. And I said, well, let's revisit this period, for over the next few months and see if we were right. Because you don't know if you're right until you have that customer that says, hey, this is awesome. And sure enough, months later, we were having our regular checkup. And the CEO told me that he had just visited a very, very large company, one of the largest companies in the country. And the chief innovation officer of this company, whose job it was to know all the cool stuff out there to solve the company's problems, said to my CEO, just call him Bob, that's really cool. Have you protected that? And the CEO is telling me this, and I was driving my car, and I said, I'm pulling the car over, Bob. You're going to pull out what we wrote 6 months ago, and we're going to see if what you showed him that he said was really cool was protected. And sure enough, it was. And that laid the foundation of this patent portfolio that we've grown for years. And because we knew we had that, that customer light bulb moment, I may want that in the future. So it was worth protecting. And we've continued to do that with over time. We only decide to protect something if we get a great response from the customer showing that they might be interested in the future.
Okay. So kind of related to that, how quickly can you get a patent?
Well, there's actually a myth there that it takes forever to get your patent out of the patent office. One of the differences in what I do as somebody who represents only startups is I realize that every patent is critical. Nope, every one of my clients, I live and breathe their work as to when we need stuff to happen. That's very different from traditional law firms and lawyers because they just get patents and they just put them literally on a conveyor belt. So what I have developed over the last few years as a practice model is because we're waiting as long as possible until we get that customer validation to file our patent applications, we are also availing ourselves of an ability in the US to get your patents basically in a speed lane, in patent applications in a speed lane in the patent office. And we are getting our patents allowed in a year or less. I've gotten patents allowed in 4 months for a couple of clients. But that requires a few things. That requires you to do a lot of work and file a patent application that not only broadly protects your innovation that you have now, as well as the innovations you may go in the future, but also tells a great story to the patent office that you are allowable. That there's, I'm not filing this patent application because I want to waste your time, patent examiner. I'm filing this application to give you a reason to allow me because it's meaningful. That does take a lot of time. It takes a lot of work. But if you need a patent to issue so that it can be valued for investment or for strategic licensing or some other business strategy that you have, you need to do it that way. Not all the patent applications we do are done under this framework. And that leads to an important point here. Business strategy has to drive how you patent. So if my client comes to me and says, I need a licensable patent in 12 months, then we're going to put it in the fast lane, spend the extra money, do the extra work it takes to make that happen. There's other situations where that may not make as much sense. It may not be that as that important of an innovation. It may be something that you want to keep confidential, and if you want to keep it confidential, you're not going to want to fast track it. There's certain other tools that you can use. Importantly, a takeaway here is there are lots of tools in the IP strategist toolbox. But conversely, when you're a patent attorney, you really only have a hammer and everything looks like a nail, right? So there's a difference in the structural framework of the advice that are given by two different in two different frameworks.
Okay. So you talked about, I think you might have touched on this, and someone actually has a question about this, and I want to go ahead and jump to it rather than save it for the end. But would what you kind of talked about there, is that a provisional application to get things started? We talked about this a little bit.
It depends on what the strategy is, right? So in the first case, when the case I told you about the two guys in the conference room, that was a provisional because we thought we had something, and then we went out and continued to do customer discovery, talk to the customers to make sure that we were right, because you don't want to file a patent application if you're not certain that it's something that's going to be meaningful for you over the long term. The fast track it can be done either directly as a utility, or it can be based upon an earlier provisional. And again, your business strategy dictates the patent strategy. In that case, with the two guys in the conference room, we filed a provisional and then we did fast tracked it. So we were out of the patent office in far less than 2 years, door to door on that one. Other clients, and this is more often for clients that are a little bit farther along, they're not early stage startups, they might have customers and they're more established. We'll go directly to the utility because we know we're right. We don't need to continue to work on our hypotheses that are associated with the product market fit analysis, that we want to make sure that is fully embraced in the utility application. The one thing, really important thing to remember here about provisionals versus utilities. First of all, I have a new client that has the worst provisional I have ever seen. It's 2 pages, and I told him you don't get priority. And you know, a 2-page provisional does not get you priority. A 10-page provisional may not even get you priority. Your provisional is only as good as what's in it. Okay. So my provisional applications very often are 30, 40, 50 pages because we want to get everything in there that we think is relevant at that point. But what the provisional allows you to do is get your date, because you're out there talking to folks, and you of course you want to get protection if you're out there talking to folks. But you also want to leave yourself the optionality of being able to add to that later. A provisional, the rule on a provisional is it has to be there, but you only have to show you had possession of what you later want to own. The courts have said you have to show blaze marks on the tree to show that you had possession or you knew what you later wanted to own. So that means filing a provisional allows you a lot more flexibility to add to stuff later. So as an example, this example, the two guys at the conference room, we thought that we had something. We thought that we had an early product market fit. We wanted to go out there and continue to talk to the customers and get more information about that, about what their insights from them. We wanted to include the customer discovery insights. So we could add, by filing a provisional showing we had possession to this thing that we later wanted to own, whatever it was in context, we could also add the customer discovery insights that could give us more optionality for future pivots, perhaps, or moving into slightly different markets, which allows you to do that. If I was to file a utility application today, I can't add to that. I can't change that language. So if you are still in an environment where you're figuring out what you want to be when you grow up, if you will, vis-a-vis what you want to own and what you want to own in a patent, then a provisional is probably a better place to go. If you know who the customers are, if you know why they're buying, if you don't really think you're going to change that much going forward, then you can go ahead with the utility, and there's not really any downside there. So the biggest flexibility offered by the biggest distinction between a provisional and a utility is how baked is your business, how baked is your innovation, and how much optionality do you think you need to pivot, change in the future. And if you need that optionality, if you're not fully baked, then go provisional. But remember, filing the track 1 doesn't really reduce the amount of time that much, because if you do, if you write the patent application the right way, you're going to get out of the patent office in less than a year, sometimes even far less if with some of my clients.
Okay. Well, we're actually getting some good questions in the chat, and I usually save these for the end, but I want to go ahead and ask the next one that somebody has a question for is, does it make sense to file for 2 small specific patents rather than one big complex application? Do we need more context on that, or does it?
Well, so this is a specific question. One thing only covers one thing, right? And if it's a specific thing that you're bringing to the market, there's not a whole lot more to own. Okay. But if you're creating a technology that's going to enable, I like to say it this way, okay, are you bringing something to the market enabled by technology or technology adjacent? Is behavior going to change when this gets to market? Are there things that are going to happen in the supply chain or the value chain? If you introduce this product to the market, is this going to change how other companies react in the marketplace? If there are multiple dimensions to what you're bringing to market, then you should file this, as I like to call them, big kahuna patents, right? Because that's where the optionality is. In other cases, and I don't really do these days because I don't find, with respect to people who are bringing products to market, I don't find this really, that I really add any value in this space, but there are people bringing individual products to market that may be relevant to patent. But a lot of times those individual one-off products don't really need to be patented because there's not enough volume or scale in the marketplace to make it worthwhile patenting. And let me bring this to an example. And I'll bring to back my Georgia-Pacific days, where my eyes were really widened on this regard. We did a lot of things. You walk through Target and look at the end caps. There'll be products that are on the end caps that say, new product, and it's basically like a refragrance of something. It's not a really big change to a previous product. And we would work really hard on those types of products at Georgia Pacific. And I was in the Dixie business, the Dixie cup, Dixie plates business. And we would bring out these products that had really small incremental changes to them. And they were under our brand. They were under the Dixie brand. And we would spend tens of thousands of dollars on patents with outside counsel. And in reality, those products were meant to be in Target or insert any other big box store. Those products were meant to be in the store for 6 to 12 months. Patents had absolutely no bearing on the ability to generate the revenue from that very short period of time that product was going to be in the store. So even though you can get a patent, does it make sense from the standpoint of your patent is going to make help you earn a multiple of that revenue that you would not otherwise have obtained? And also for small inventors or small companies, you also have to bake in the cost of that protection. If you're a small company thinking about going out there and protecting your patent rights, I can almost guarantee you it's probably going to put you out of business. But the lawyers will tell you can protect your invention, and they'll charge you hundreds of thousands of dollars to do so. But in reality, it's probably not the best way for you to be spending your money. And most companies shouldn't be. Most patent owners shouldn't be thinking about protecting their products vis-a-vis patents. They should be thinking about how patents can give them a seat at the table that they wouldn't otherwise have. How they can get a partnership with a large company that wants access to their products or their technology, or how they might be able to sell their company that's enhanced, that has a value that's enhanced by patents.
Okay. Well, I'm just going to keep going with these audience questions, because there's some that I didn't even think of, because honestly, I don't know about this one, but let's see. Alexander asked, what is the difference between independent claims and dependent claims, and why or how, in terms of strategy, would you want to file numerous dependent if the independent is the primary thing you are patenting?
Okay, so I learned from a client that I actually trained, and he's trained me on how to articulate this. Think of the independent claim as a Christmas tree, and the dependent claims are the ornaments on the Christmas tree. The independent claims are the broadest part of the invention. The dependent claims add more limitations, add more stuff to those, the ornaments. That question has to be separated into the types of patents you're doing. If you're patenting an invention, the dependent claims can be important because it's likely that there's a lot of other prior art out there, and adding the dependent claims will make it so that you are patentable over the prior art. It's unfortunately, a lot of patent attorneys don't put a lot of thought into the dependent claims. But because I don't do inventions and I work with innovators, there's a different strategy to dependent claims and independent claims that I work with, which is why my clients' cases get allowed. We talk about independent claims as the broadest framework of the invention that you want to own that does not read on the prior art. Okay. And my clients are doing new stuff that's meaningful. And in order to show the patent office that we're entitled to a patent, we have to make a clear and unambiguous description of our innovation in the claims. However, what happens when your patent application is getting examined, it's just the nature of the beast, if you will. The patent examiner is going to reject you. And so what like I said, my guys are innovators. It's novel and obvious what we file, but the examiner begs to differ, because they have to in most cases, or they perceive that they have to. And so what we do is we prepare dependent claims that are strategically framed so that if I add that dependent claim back into the independent claim, I don't care. And as an example to this is, I often use, say you're the first person to claim the innovation that is a car with an internal combustion engine. It has a carburetor, or now a fuel injector. It has an engine. It has an exhaust system. It has a steering wheel. It has a place for the driver to sit. It has a brake. It has other things that if you put in the claim, they're non-limiting, because the car will not function unless you have those things in there. And you might put those in the independent claim. You might put some of those in the dependent claim. Does a claim that has all of those features in there read on a electric car? No, but you haven't invented an electric car. You have invented a car with an internal combustion engine, so you don't care how much stuff is in the claims. And then you might have to, in this example, I might have to put a gas tank as a dependent claim. And the examiner might cite some bogus prior art, which they do. But I can now add a gas tank from that dependent claim up into there. And because it's an internal combustion car engine, it's got a gas tank. So I don't care if I have to add that back in there. So I guess to answer the question, dependent claims are very important if you do them strategically, because you know that it's a game theory. It's all a game. It's all a game with a patent examiner. It's all a game with anything in life. You have to game it out to see how you're going to win. And dependent claims help you get ahead of the inevitable pushback that you're going to get from the patent examiner.
Okay. So another question, you had said previously you got to think about how a patent will make your business money. And the question is, when a startup is thinking about being acquired or they're coming up with their exit strategy, how can a patent help?
So that's a great question. I like to say we don't patent for the product we have, we patent for the exit we want. So what you have to determine is whether or not patents matter in the environment in which you're working. That's the first thing I do for any new client. I will go out there and I will take a look. I will ask them, who's the competitors? Who are the likely acquirers? What else is going on out there? And it's a really easy search. I don't have to do it. And I'm surprised that more people don't do it. Just as a first order question. What do the patents look like in the space? And since my clients are technology, are companies that are solving problems enabled by technology, there's usually companies out there that are patenting. And so in the space where I know not everybody's in these kind of spaces, but I usually see companies like IBM or Google or Accenture, insurance companies. And what these companies do, and I know this from my time in corporate America, working for a large high fortune company, is that these companies come up with their 3 and 5 year strategy plans. They know that they're going to be doing something in 3 or 5 years if the technology evolves the way they think it will, they want it to, and what I see is they get patents that are looking toward the future of where they want to be. And very often what I see is that my clients are working in a space where they are creating the technology that's going to enable these large company solutions to actually happen. These companies are Google's patenting something that Google's probably not a good example because they actually can do stuff. IBM is patenting stuff that they know they want to sell in 5 years, but they can't do it today. They're relying on other companies, technology innovators, to create the technology that allows those products to reach the market in 5 years. And so when I'm creating patent applications for these technology enabled innovators, we are looking to see how we fit into the already established but early stage framework that the larger companies are going to seek to be in. And as an example here, I had a client years ago, in startup, when you're in the startup world, years ago means 5 or 6 years ago, by the way. So but it seems like forever ago because technology has evolved so quickly, but they were in the predictive analytics space. And they had some really cool technology to be able to tell when big machines were going to fail. And it was just really just off the chain, innovative at the time. And they were never going to get big enough, or they should say they were never going to have enough money to scale in a way that would allow them to be a real player in the marketplace. And but we had some really good patent applications, and they were bought by a high fortune company, very high fortune company, primarily for the patents, because they didn't have any customers. Certainly they had some, they had some technology, they had some algorithms, but this large company that had, I don't want to say this large company waited too long to get into the market, but this large company, by buying my client, was able to buy entry into the market that they didn't have to build. So they were effectively able to sit back and watch the technology evolve. And then when they were ready, the large company was ready to enter the market, they could go out and buy this small company for basically a pittance and bring them in and not just have some place to start with the technology, but they also had the ability to keep their competitors from playing in the space because they bought my client's patents. So we were never going to be able to protect. So just think if, my small client wasn't going to protect their invention with this really great protection we were able to get, because we're not in the business of suing other companies. But this large company has armies of lawyers that if they're not suing other companies, they're not doing the work, right? So the exit that we wanted was into an incumbent company that had a business model that included patent enforcement. And that was our exit. I have another client that I've been working with for years. They thought that they were going to be diagnosing a medical condition. And it turns out that there was an incumbent medical device company, established medical device company, that was looking for innovation that would help drive sales to their existing product line. And so my client got patents in a year that this incumbent established medical device company licensed, and that has been the primary way that my client has funded its continuing R&D and developed the portfolio, developed the business, developed all its other products without having to take dilutive capital. Well, they started out, they didn't know that somebody was going to say, hey, your stuff's really cool, we want to license it. But when they were given that opportunity to gain revenue in that way, they pivoted themselves to obtain that revenue so they could do the other things that they really want to do in the future.
Okay, I'm just going to keep zooming through these so we get to everybody. But and you might have touched on this one at the beginning when we talked about the myths and misconceptions, but someone's asked, what are often the 3 things that cause a patent application to fail?
Top one is expecting the patent attorney to do your job for you. You only get a patent to cover your business model, what you're doing. Your patent attorney's job is to get you a patent, not to get you a patent that creates value. The courts have said that. You can't, if your patent attorney gets you a patent that's worthless, and they did it in a way that was legally defensible, too bad, so sad, you lose. Okay, so that's a big misconception. Second misconception, it was kind of a corollary of the first. People want to hire patent attorneys that have a technology focus in the area that the product or service or technology is in. So an electrical attorney, somebody who's got an electrical based invention will go talk to electrical engineer patent attorney. Why do you want to hire somebody who has the same technological expertise that you do? They're just basically going to be transcribing your technology for you in a way that that they're doing your work for you. In other words, for me, I have clients that come to me and it's stuff that I have absolutely no clue what it is. And I tell folks that, you know, my ignorance in your technology, my ignorance in your customers, my ignorance in your business is a feature, not a bug, because I ask really good questions because I'm clueless. And you know, we still have a joke about a client I've worked for years. So actually, the 2 guys in the conference room, the scientists, I always say to him when we're doing one of our big applications, I say, Tom, yeah, give me 3 pages of math. You know, I can't read it, but just give me those 3 pages of math. Make sure it's right. Because we're not claiming the math. We're not claiming the technology. We're claiming the solutions that are enabled by that technology. And I guess the third one would be that it's what I said before, that getting a patent creates value. It's business. It's a viable business solution with a real customer that's scalable, that creates value. But again, you know, remember one thing. Remember this: 100% of patents make money for 100% of patent attorneys. You know, be very cautious when a patent attorney tells you you need a patent.
Okay. So someone else is asking, can you talk more about invention versus innovation? Can you elaborate on that?
So let me think of a practical example. That's not, okay. Yeah, this might help. We might have some medical entrepreneurs on the call. Typically, you know, you need a patent if you're in the medical device space. Okay. It's because the environment is largely dictated by patents in a value. You need to have a patent. So let's talk about medical innovation. So years ago, I was asked to evaluate a patent by an entrepreneur I know who was thinking about joining this doctor to build a business around this patent. And this doctor had been I don't remember exactly what it was, just say a gastroenterologist, surgeon, operating on the stomach. And he had for years and years and years experienced this problem when he was operating on people. So he got a patent, and I know he paid an ungodly amount from a large law firm here in town. I got the number, it was crazy. And he got a patent on a tool that would hold a particular part of the area open while he was doing the surgery. And the claim was that the patent was directed to that tool. And I told my friend, who was the entrepreneur, who was the CEO entrepreneur type, who was thinking about building a business around this patent, I said, the patent's worthless. And he said, why? I said, because this this medical doctor created an invention that solved the particular problem that he was, of keeping the opening in the stomach the way that he needed to during surgery. I said, but there's probably 62 different types of tools that can provide that same solution. It was truly an innovation that the doctor was looking for. He was looking for a way to do the surgery better, something that would allow him to be more effective in his surgery by keeping the opening in a particular way. He invented one way to solve the problem. That was an invention. But there were so many other ways to solve the problem. So now that he's shown everybody what the problem is and how to solve it, you could make any other tool that would work the same way, that would not infringe his patent to the specific one type of tool. So the innovation was the way to actually create the environment to do the surgery better, which he knew better than anybody. He'd been doing these surgeries for years. But his patent attorney directed him to file a patent on the tool, which was just an invention. And you don't want to build a business around a single way to solve a problem. You want to build a business around a protected solution that could be implemented by any number of tools, some of which you can see and many of which you can't. Does that help?
I think so. Okay. For the person who asked, if you want to give a thumbs up. So we got about like 12 minutes left, and we got to wrap up just a little bit here, but there's another question. How would filing a utility patent and design patent on the same product be a detriment to a company or their claims?
I don't know why people file design patents as a strategy. Design patents would be, in my view, I work with startups, would be a strategy that a company like Georgia Pacific would do to meaningfully protect some non-functional part of a product. So as a strategist, I haven't gotten any design patents since I left Georgia Pacific almost 15 years ago. Now, that specifically is a legal question there. I'm not really here to solve legal questions, but the design patent has to be the non-functional. It has to cover ornamental, non-functional aspects of a product, whereas a utility patent covers the functional aspects. You have to tread carefully there, because if you protect functionality in a design patent, your design patent's not going to be valid, and it's an area fraught with complexity and legal risk. And in that case, there's no reason why an entrepreneur should seek to go that way. And if their IP lawyers are suggesting that for them, I would say with respect, their IP lawyers don't know what they're talking about in the context of a startup company.
Okay, so related to that, what are some things that you should look out for when you're searching for an IP attorney? What are some key characteristics? That was another question.
That's a great question. So first of all, the nicer the swag that they give you, the more concerned you should be about them. There's also situations where there are very personable, some would say smooth or slick, partners that go out and do the business development. And then when you get them, when they get you as a client, you're relegated to a first or second year associate because they don't earn very much money from you. Okay. The economics of law firms make it very difficult for lawyers to make money on small companies. Period. End of story, especially given all the overhead associated with that. One question that I would ask for you to think about how to ask it in context. How many of your clients have had successful exits that can be attributed in significant part to the patents? Some folks won't know. Some folks won't care. Surprisingly, some folks will say, I can't tell you that it's client confidence, and it's not client confidence because it's generic information, right? And if somebody can tell you, yes, they've been successful, then ask them what kind of technology it was. You know, if it's medical device, yeah, it makes perfect sense. But if they can't point to a company that has been successful in an area that's relevant to your type of business, I would be very concerned. But again, I'm not going to give a lot of. I don't want you all to think I'm giving a lot of shade to my colleagues and peers. It's the nature of the business. You're not in the business to create value, to make money for your clients. You're in the business to make money for yourself, and the clients making money is an incidental effect of the work that you do as an attorney. Just the nature. That's the way things are. It's buyer beware.
There you have it. There's your insight into what to look for. That's pretty incredible. Okay, so we're kind of wrapping up here. I'm going to ask my questions, but if we've come to the end of y'all's, if you want to put any more questions in the chat, feel free to do that. And I'm going to go ahead and ask my two last questions. I always ask, what's the biggest takeaway you want people to have from your talk today? Is the first question.
Patents and IP can be the difference between a successful exit and a so-so exit. And knowing the difference is your job as a business person. Don't leave that to the lawyers, because the lawyer's business is the law, not your business. The second one is that ask for your patent attorney or IP attorney to be accountable. One of my biggest complaints about my profession, or I should say my former profession, is that we're not, when clients ask us a question, we always say it depends, because that keeps us out of trouble. Yes, there are so many qualifications. There's so many things that can go wrong. But that's not a reason to say that I can't be accountable for what happens. I don't think anybody should go to work every day without an obligation to be accountable for results. And if they're not accountable for results, they should tell you why up front.
Okay. So knowing all that we know today, where's the best place for listeners to connect with you and learn more about your work? I know you have a podcast that I didn't talk about.
So I have a couple of things. So I've been blogging since 2008. People don't read blogs anymore. I'm on LinkedIn. This has been an evolution for me because the IP strategy thing, the business is about as old as I've been around doing this since like 2008. It's much more established. It's much more established now, but there's not enough people who are really in the space. So I continue to put content out there. The best place is, yes, the podcast, but podcasts are becoming too many podcasts. So I've kind of moved away from podcasts because I'm an innovator myself. So I've recently put up a YouTube channel called Winning with Patents. And I've got two video presentations there so far. These are going to be exclusively for startup entrepreneurs. So it's probably be the best place to get content if you subscribe to that channel. I very much prefer that people go to this content, to avail themselves of this content before they contact me directly, because I can't talk to everybody. I can give you, a half hour here and there, but if you have availed yourself to this content first, you can ask me better questions. And one thing I tell potential new clients, and I'll tell you here on this call, I can't represent everybody. That's the other thing too. I want more people to be engaging in this world of IP strategy and being accountable to results to entrepreneurs. But I always tell people that I will always tell you the truth, even though you may not want to hear the truth. And I will always treat your money like it's my money. And that's, if I and the people who are listening to this are not working together, which I think is highly likely, just by the nature of things, that at least you would expect those two things from anybody you engage to help you create value and enhance the value of your enterprise.